In a swift reaction, the opposition coalition says no Supreme Court judgment was delivered against the governor of Rivers State, Siminalayi Fubara, and the factional speaker, Victor Okojumbo. At a live media briefing monitored on TVC News earlier, the spokesperson of the opposition lawmakers, Ikenga Ugochinyere, argued that contrary to the reports in many media, the judgment is in favor of the governor.
There was no judgment today from the Supreme Court that affected the status of Okojumbo, who is the rightful Speaker of Rivers State House of Assembly, and there's also no judgment that was lost by Fubara. What happened today is that the appeal that was filed by Governor Fubara over the issue of where the budget of 2024 should be presented, that the governor, knowing that it is now a mere academic exercise because we're in 2025, taxes have been collected, revenues have been collected, and budgets have been executed, money have been spent. So why are you now in Supreme Court waiting for an appeal on whether you should represent before they sack lawmakers? So the right thing is to withdraw it because it has been overtaken by events. 2024 have expired. 2025 is what is being implemented now.
Legal practitioner Jiti Ogunye joins me on the news at 10 for more updates. Mr. Ogunye, what exactly is the implication of this judgment regarding the 2024 appropriation bill of Rivers State? Does it mean the money should now be returned to the Treasury, or what exactly does this law mean?
Well, good evening, Nigerians. The decision that was made today by the Supreme Court was a decision dismissing the appeal that was lodged at the Supreme Court by the appellants against the decision of the Court of Appeal, and being a dismissal based on an application for withdrawal of the appeal on the ground that the issue determined by the decision being appealed against had been overtaken by events, essentially because the budget was a 2024 budget. No mandatory pronouncement was made by the Supreme Court on what to be done on the consequence of that decision of dismissal. So what we're only left with, therefore, is the decision of the Court of Appeal affirming the decision of the Federal High Court, Quorum Omotosho J. So to answer your question directly, we have to go back to the first judgment on the matter. We declared the non-presentation illegal. And so in determining what had to be done following the decision, we can hang on to that judgment, that first judgment, or even its affirmation or appeal to decipher what had to be done. It merely declared what was done illegal and that the budget be represented. Beyond that, what had to be done or what ought to have been done will remain a matter of speculation, because we're now talking about what happened in 2024 in the past.
All right. But does it then suggest that the Supreme Court has also identified the Martin Amewule-led House as the authentic assembly, or is this law standing on its own without prejudice to that matter on the authentic assembly?
Yes, the judgment, it will appear, stands on its own. Suffice to say, however, that there's still a number of appeals that were heard, about 6 of them, emanating from the Rivers State political imbroglio, which are yet to be determined by the Apex Court. And so we await the decision of that court, of the Supreme Court on the subject. But let me just say generally, when politicians holding fast to power want to take advantage of one another, then have recourse to the judiciary as an extension of their political battlefield, it is necessary to pull back and ponder why politicians do this. My little knowledge of the law, and I'm not delving into the merit of the matter, I can't do so, is that once you are alleging that somebody has defected and that his seat has thereby been declared vacant, or he shall vacate his seat. It will take a pronouncement of the court of law to say so via the declaration. It's a court of law that declares and then vests legality and legitimacy on that vacation of seat. A Speaker of a House, the Senate President cannot just by word of mouth say you vacated your seat, so go away. And so if there's not been a pronouncement to that effect from the court of law, a positive one, saying that they are no longer members of the House, all the while that the governor and his three legislators were saying they had constituted the legislature and the other persons are defected, so they are out, all those shenanigans will be illegal until a court of law will have said so. And they should have waited for the court of law to say so, instead of parties resorting to self-help and saying, you are defected, therefore, I no longer recognize you. It is not in the mouth of the governor to so say, or fellow legislator to so say. It is the court of law that will have to pronounce it. And it is obvious, if you have three arms of government, and the judiciary, the third arm of government, is the arbiter and is the body that interprets the law, is the arm of government that interprets the law. Once the legislature and the executive are in combat, it is the judiciary that they should have recourse to. So it's therefore not valid for the governor or some partisans to then say they are defected and that therefore they are the one to enforce the defection. I
hear you, Mr. Ogunye, and this brings us to another point, which is another thing that has happened, that the current members with the Martin Amewule House have actually not collected salaries for more than a year. And does this judgment mean that they will now be paid their backlogs if the budget is represented by the governor?
The picture will get clearer with the judgment to be rendered on the other cases that I've talked about. My view is that what has played out in Rivers State has happened in other states of the Federation. We saw what happened in Edo under Obaseki when the governor said I proclaimed the House and that those who were shut out in that process will no longer be brought back by another proclamation. And so they were out for almost the life of that night's assembly or 8th assembly, as the case may be. So the point is that for too long, we've seen this kind of thing happen. And, my view is that either the Federal Attorney General or those who are in the National Assembly should pay more attention to what happened in the states to ensure that representative democracy, thrives. Democracy does not thrive only when a governor, like a lord of the manor, is given absolute immunity and liberty to do as he likes. A House of Assembly is a house of representatives of the people. And so if there are issues of remuneration or vandalism, destroying a house, removing their roof, to make it impossible for them to meet, that's an act of treason being committed by a governor. And therefore, the matter should be taken more seriously than it's been taken hitherto. That's my candid opinion.
Okay, and we would have to leave the conversation there. Legal practitioner Jiti Ogunye, thank you very much for your time on TVC News.